Thank you very much, Your Excellency. Thank you very much for that opening statement. We will now turn our attention to the first round of questions by the committee. This will last for around 35 minutes.
Les autres membres du comité pourront également poser des questions s'ils le souhaitent en levant leur pancarte. Je vais laisser la parole au rapporteur, en commençant par Madame Souela Janina. Vous avez la parole, Madame.
Thank you, Chair. I would like, first of all, to welcome the distinguished Chair and other members of the delegation of Cambodia, and also to appreciate the spirit of cooperation that has been expressed through the remarks that we have already heard by the distinguished Chair. As co-rapporteur with my colleague Barbara Rochbiller, we believe that it will be a good occasion that we exchange with the members of the delegation on the implementation by the State of Cambodia of the obligations that arise from the ratification of our convention. And this will be based on the report that you have presented, although it's been somehow a late submission, but together with a list of issues and the replies that you have sent to us, also with the input from civil society, we believe there is a good basis that we have a constructive dialogue together, today and tomorrow. As I mentioned, the civil society, the participation of civil society, I will start with that remark, is paramount to the work that we consider state authorities should do in the preparation of the report. It is in our guidelines, but also you may see it in our list of issues and questions that we have raised to you. You have replied that there has been consultations for the preparation of the report that has been presented to our committee through also the office of the High Commissioner in Cambodia. We would like to hear from you more concrete information on the consultation process which has been carried out to prepare the State Party report, particularly regarding a meaningful involvement of civil society organizations in this process, and more specifically, if there are associations, civil society, which have a connection or deals with the phenomenon of enforced disappearance. That would be of great interest to hear from you. As mentioned also in the speech by the distinguished chair of the delegation, His Excellency, that we have taken note that there has been a draft law started from 2021 on the setup or establishment of a national human rights institution. And we hear now that it's in advanced phase. So we'd be very much interested to know more details on the progress that this draft law has, because it is important that human rights institutions is established in the country in accordance with the principles that are relating to the status of national institutions for the promotion and protection of human rights, or the so as known the Paris Principles. There is a question that we have posed to you on the status of convention, and there is a reply in paragraph 10 of the list of issues. We would like to have more information about the number of cases in which national courts have applied the convention and the measures that have been taken within the state party to ensure that this kind of cases are done or are addressed in compliance with the convention. Another question that I would like to pose to you is regarding the acceptance of Article 31 and 32 of the Convention. We have taken note of the replies that you have sent to us, that you will consider an appropriate time and circumstance to prepare the procedure for the making of the declaration. And more specifically, it's paragraph 4 of your replies to the list of issues. However, we remain of the opinion that some more concrete engagement on that regard is needed. We would like to know if there is any particular obstacle that you may consider. We would be ready to discuss them with you. If there is a need for any clarification you may need, please pose these questions to us, because, in fact, the procedure in Article 31 it is known as the competence of the committee, but it is the right of the citizens, of every citizen of Cambodia, to have a safeguard for the protection of their rights under this convention. And we would like to emphasize the importance of further efforts from the Kingdom of Cambodia to accept it. So please, if you have any further information about that, it would be very much appreciated. There is a question that we pose to every state party regarding statistical information. You have replied that there is no case of enforced disappearance, but still, we would like to know if there is a system on which you may reflect cases that are disaggregated by elements that we have posed to you, including gender, including age, profession, ethnicity, that are important to identify the causes of enforced disappearances as well. Maybe if it's not related to the cases of the present, it can be related also to the cases of the past that you have already mentioned, Your Excellency, and put a lot of emphasis on the particular period of suffering during the Khmer Rouge period. So we would like to know if there is also some statistical system to gather information about the past breaches of human rights, and including in particular cases of enforced disappearances. In paragraph 12 of the replies of the list of issue, you have informed us that the competent authorities may not use circumstances such as a situation of war or threat of war, internal political stability or public emergency as a justification to prosecute, arrest, hold, or detain any person without properly complying with the provision of the law. We would like to know if there is any explicit provision on domestic law to guarantee the non-derogability of the right not to be subject of enforced disappearance. We have taken note also on Article 38.3 of the Constitution that you have mentioned, but we would like to know if there is any specific provision to guarantee this non-derogability of the right. We would like also to know, under the same situation, if there is any case where the state of emergency has been proclaimed by the King in accordance with Article 22 of the Constitution in the Kingdom of Cambodia. Would you inform us, please, if any rights have been derogated during these situations? The committee also would like to know about the law on the management of the nation in state of emergency, which was promulgated in April 2020. Would like to know if the government exercise any right to constrain any fundamental right and freedom, and under what conditions, which are those rights that can be under the competence of the government to be constrained. Regarding the fact that you mentioned several times, you put the emphasis on the fight against impunity for past human rights violations. We would like to know and to ask on the progress in the investigation and prosecution of those responsible for past human rights violations, including extrajudicial killings and enforced disappearances that occurred after the signing of the Paris Peace Agreement in 1991. The committee would like also to see how the cases that you mentioned in the extraordinary chambers in the Court of Cambodia have taken any analysis on the merits of such human rights violation, and if there are cases that has been already remained undressed, which will lead some way the impunity, which of course it's not desirable for the members of this committee and also for international community in general. When it comes to the legal framework that you have in place already to address cases of enforced disappearance, which does not amount to crime against humanity, let it put like individual cases of enforced disappearances. We know that there is no autonomous offense of enforced disappearance in your domestic legislation, and you refer to a number of articles of your criminal code, like Article 235 or Article 255 on illegal arrest, detention, or confinement, and Articles 588 to 591 on abuse of power against individuals. We have expressed several times during dialogues with state parties in this committee that a range of existing offenses and similar acts are not sufficient to encompass all the elements of enforced disappearance as provided in the Convention, or do not reflect the gravity and specific nature of enforced disappearance. However, with this understanding, we would like and ask you to inform us if you and when do you plan to consider as appropriate the initiation of the review of your criminal norms to comply with obligations of the Convention under Articles 2, 4, and 7. At the same line, we'd like to know if, under this kind of consideration, what would be the appropriate penalties to be set on cases of enforced disappearance. And another question that I will put not for the future but for the present. If in a court case in Cambodia, a case of enforced disappearance will be reviewed, what will be the minimum and maximum penalties that the judge may confer to this case, having in mind that there is a lack of a specific and autonomous crime of enforced disappearance? At the same time, could you please explain a little bit the situation with mitigating and aggravating circumstances in your legislation? Do you recognize this kind of notions and how they are applied in the actual legal framework? When it comes to the legal responsibility of superiors, could you please explain paragraph 10 of the report and explain if there is any circumstance provided by the law to excuse the criminal responsibility of the perpetrator, co-perpetrator, instigator, or complies to crime against humanity, a crime of genocide or war crime. So please, the question to be more concrete is to be more clear on your information in paragraph 10 of the report, because it's not clear to us what is the responsibility in these cases of superiors. In relation to the element of statute of limitation, we would like to know which is the status of limitation which is applied in the case of enforced disappearances, which does not amount to crime against humanity. So we are talking about enforced disappearances as individual cases. Is this 15 years, or is there any time limit different from that I'm mentioning to you, that we've seen according to the report? Could you please explain how the status of limitation is considered to be commenced? Do you have in your legislation the definition of a crime of continuous nature and how it is applied in practice? Does enforced disappearance fall under this category or is considered differently? I would like to have also a question, a clarification in relation to your replies to paragraph 12 of the list of issues. I would like to know what happens in the situation when an alleged perpetrator of enforced disappearance committed abroad is present in the territory of Cambodia and he is not extradited or surrendered to another state. Is there a condition of double criminality that you ask from another country, in that case the country of citizenship or the country where the crime is committed? Taking also into account that enforced disappearance is not criminalized in your national legislation and that the law on mutual legal assistance in criminal matters contains a reciprocity requirement, how can the state party, in this case Cambodia, ensure assistance in case of enforced disappearances? I would like to pose also a question that has been raised also by other treaty body and our colleagues in other committees regarding the impartiality of the judiciary. Because although there are measures that have been taken by the state party to strengthen the independence of the judiciary, still, as we understand, There are still concerns about the persistent lack of an independent and impartial judiciary and about the high number of allegations of corruption within the judiciary. Could you please explain how the law of 2014 on the organization of the courts, the status of judges and prosecutors, and the organization and functioning of the Supreme Council of the Magistracy guarantee independent selection and promotion processes of members of the judiciary? Could you please also provide information on procedural safeguards establishing the anti-corruption law and measures taken to carry out effective investigations by the anti-corruption unit? I have another question about the military jurisdiction. It's short, but please, it's very concrete. Are military authorities competent to investigate or prosecute cases of enforced disappearances? I would like also to have more information about the measures that the state takes to protect from prosecution and ill treatment any complainants, witness, or relative of enforced disappearances, and if the authorities can or have the legal framework and also the practice of investigating alleged cases of enforced disappearance, even without a complainant from the victim or someone who is interested to put this case of enforced disappearance into the attention of the competent authorities. In Article 111 of the Code of Criminal Procedure, we see that judicial police officers have the authority to conduct a primary investigation at their own discretion or at the request of a prosecutor when they have knowledge of facts which may be a crime. Could you please, in this framework, explain how it is compatible with the Convention's standards of reasonable grounds for believing that a person has been subjected to enforced disappearance, or to put it more clear, how is the subjective assessment of investigator takes place in cases of enforced disappearance? The last question is related with the possibility to suspend from duty any law enforcement agent or security forces who can infringe the investigation of enforced disappearances. In paragraph 34 of the replies to the list of issues, you refer that in the absence of legal provisions, the prosecutor may in practice delegate the investigation to another law enforcement. Could you please explain how this functions in practice, and if there is or there are concrete cases when it has happened? Would be very much interested that if you could really illustrate this in practice. So with that, Mr. Chair, I finish with my question and thank the delegation for the options and opportunities and replies they will have in further part of the dialogue. Thank you.
Merci beaucoup.
Thank you very much, Madam Jelina. I'll now pass the floor to the second rapporteur, Madam Barbara Lochbihler.
Also a very warm welcome from my side. It's good to have you here, also in person, and to discuss. I will take up the issue of urgent actions. In the Convention in Article 30, it provides the committee with a very advanced mechanism of urgent action regarding cases of alleged enforced disappearances. And our committee has over the years gained rich experience in following the specific form of comprehensive search and investigations. Now, in your reply to the list of issues, you state that the Kingdom of Cambodia does not have any specific formal mechanism for addressing urgent actions transmitted by the committee. You further state that the General Commissioner of the National Police or the Royal Gendarmerie of Cambodia can be tasked with searching for disappeared persons, and legal action, such as inquiry and search, can be based on the Code of Criminal Procedure. Now, could you please describe how you develop immediately after you receive an urgent action request from the said committee a comprehensive action plan and a timeline for the exhaustive search and for the exhaustive and impartial investigation of alleged enforced disappearances? which takes into account all the available information, including the context in which the disappearance took place, in compliance with its conventional obligations under Article 2, 12 and 24 of the Convention. And how do you ensure that this strategy is evaluated periodically and complies with the requirements of due diligence at all stages of the search process, including the launch and conduct of the search on the authorities' own initiative? How do you guarantee the professional competence and independence of all the staff participating in the search, in compliance with Principles 6, 7 and 8 of the Guiding Principles for the Search for Disappeared Persons? How do you ensure that the strategy adopted determines the activities to be performed in an integrated, efficient and coordinated fashion, and that its implementation relies on all necessary and appropriate means and procedures to locate the alleged disappeared person and investigate the alleged enforced disappearance, in compliance with Principle 10, 11 and 12 of the Guiding Principles for the Search of Disappeared Persons? And how do you provide the committee with updated information as to the measures taken to implement each of these recommendations and about the result of these actions? So these are my general questions on urgent actions. Our committee had issued so far 4 urgent actions on Cambodia. There are 2 ongoing urgent actions. One from Kem Sopat, it's a 16-year-old boy who disappeared during a violent crackdown by the Cambodian security forces against striking garment factory workers in 2014, near the Canadian Industrial Park in Phnom Penh. A short investigation was carried out with few findings made public and no action known to have been taken as a result. Please could you update us on this case, particularly on the burned human remains found at the military brigade base in May 2014? On what basis were the remains determined to not correspond to the disappeared child? Do you have utilized modern forensic technology? If not, would you like to receive assistance in having access to forensic technology? Please also inform us if any member of the security or armed forces has been suspended or prosecuted for this incident. And then the second ongoing urgent action case is the one of Mr. Vanchal Learm Satsaksit, a Thai political activist affiliated with the United Front for Democracy Against Dictatorship, who have been living in self-imposed exile in Cambodia from 2014 until the time of his reported disappearance. The investigation you did has not made apparent progress despite the existence of eyewitnesses to and CCTV footage of his abduction, attackers, witnesses, and the vehicle used in the abduction. And different mandate holders of the Office of the High Commissioner for Human Rights addressed frequently the case of Mr. Vanchalayam Satsaskrit. Let me also refer to the recent report of the Special Rapporteur on Cambodia from October last year. He lists 20 benchmarks on human rights implementations in Cambodia. And one is follow up effectively on cases of enforced disappearances and other key violations concerning Cambodians and foreign nationals, especially to overcome the atmosphere of impunity. So please update us on the respective steps you have taken to develop an effective search and investigation strategy and provide us with the actual update on the findings of this case. And then we have had 2 urgent actions which we closed. It was the urgent action number 568 and from 2019 in response to Mr. Nguyen Sum's alleged enforced disappearance. In 2019, Mr. Nguyen Sum, a Cambodian farmer, was arrested along with his son by members of the Prea Viher Environmental Department and held overnight in the Kulin Promtep Wildlife Sanctuary headquarters. While his son was presented to the prosecutor, Mr. Nguyen Sum disappeared. This urgent action was closed based on information provided by the State Party on 3rd of April in 2019. The State Party informed the committee that Mr. Nguyen Sum had been located on 31st of March 2019 in Phnom Penh and was reunited with his family. The committee registered also the urgent action number 782 in 2019 concerning the alleged enforced disappearance of Mr. Osman Karaka, a dual Mexican-Turkish national. He was arrested on 14 October 2019 by counter-terrorism police at a bank in Phnom Penh in response to a request by the Turkish authorities concerning a purported fraudulent Mexican passport. He was subjected to enforced disappearance from 14th to 18 October 2019 and was deported to Turkey on 19th October 2019 under suspicion of involvement in terrorist activities. The urgent action was closed because Mr. Osman Karaka was located. He was arrested in Istanbul after being deported from Cambodia. The Working Group on Arbitrary Detention issued a decision against Cambodia and Turkey in 2020, concluding that Mr. Karaka was subjected to arbitrary detention and other human rights violations under the Convention. Please, could you inform us about the steps taken and lessons learned from this case of a deportation after a short-term enforced disappearance in order to prevent such enforced disappearances in the future? Thank you, Chair.
Thank you very much, Madam. I now turn to my colleagues to see whether or not there are any questions they would like to raise at this point in time. But of course, there'll be an opportunity when we reach follow-up questions if they so desire. I see no flags raised, so we will now take a 15-minute break to allow the delegation to organise its answers. And so we will resume at precisely 4:02 p.m.